For many of you, welcome back to the Environmental Law Institute. My name is Chandra Middleton. I'm the Director of the Associates Program here, which means I'm in charge of membership and outreach and education. If you want to learn more about our nonpartisan environmental think tank, please check us out online at eli.org. So this is the 5th seminar in our summer school series, Law and Policy of Products Regulation. The series has been made possible by our members and by co-sponsorship from the DC Bar's Environment, Energy, and Natural Resources Section. So without further ado, thank you very much to Sheryl, Dolan, and Lynn Bergeson for joining us today. Lynn counsels clients on issues pertaining to chemical hazard exposure and risk assessment and risk communication as the owner of Bergeson and Campbell. She has earned an international reputation in the legal and regulatory aspects of conventional and nanoscale chemical regulatory programs and specializes in chemical product approval and regulation under any number of acronyms, including TSCA and FIFRA, which you'll learn about today, and the European Program REACH, which you might also learn just a little bit about what that means, as well as nanoscale substances and nanomaterials law, policy, regulation. We are also joined by Sheryl Dolan, who also works at Bergeson and Campbell, and she works with registrants of agricultural and other conventional pesticides, antimicrobial products, biopesticides, and plant regulators to register and manage compliance with requirements under FIFRA, which is the Federal Insecticide, Fungicide, and Rodenticide Act. She also helps reduce environmental risk and improves product stewardship practices for clients by assisting them in assessing and improving compliance practices. And you can find more about what they do on our website. But without further ado, I will turn over to Lynn.
Thank you very much, Chandra. And good afternoon, ladies and gentlemen, and for those of you on the phone, it's always a pleasure to be here. Sheryl and I are going to spend about 2 hours on TSCA and FIFRA. I'm going to handle the TSCA part. But before I begin, maybe just a little overview of who all you are. How many of you are practicing lawyers? Well, what do the rest of you do? Are you interns, summer interns, at law firms, federal government? Okay. Anybody with EPA? Okay, a couple of EPAs, good. All right. Well, this is an exciting area of the law. I know sometimes you might think TSCA, FIFRA, aren't those the more arcane statutes? We've been probably listening up to more traditional federal regulatory statutes, including the Clean Air Act, the Resource Conservation and Recovery Act, CERCLA, Clean Water Act. What we're going to talk about today are the 2 federal chemical use laws. As I said, TSCA, the Toxic Substances Control Act, is the federal law that regulates industrial chemicals. And Sheryl, my colleague, after I leave, will be addressing the Federal Insecticide, Fungicide, and Rodenticide Act, which is the regulation of pesticides. So if you're a chemical substance, you really need to fall into one or the other. And some chemicals fall into both categories, depending upon the use. So we'll get a little bit into that. One thing these 2 statutes have in common is they are both risk-benefit statutes, which means the government is asked to weigh the benefits of a particular regulatory action, whether it's a product approval or a restriction on a chemical, versus the risks of that particular chemical. And the risk-benefit equation is a difficult, complex area that is really one of the most interesting areas of the law these days because it involves the intersection of law, regulation, science, policy, human health. I mean, after all, these are statutes that regulate chemical substances. And we live in a very chemophobic society today, not just the United States, but the world. We'll talk a little bit about that as we progress, but this is why, for those of you that are aspiring attorneys or looking to find policy positions, Washington is a terrific place to be in, because these 2 federal statutes are really not delegated to the states. It's another critical difference. If you have been a participant in the ELI programs throughout the summer, you know that the Clean Water Act is delegated to the states once the state achieves a particular status in implementing the program. The same with the waste law, the same with the air law. These two statutes are managed by the federal EPA here in Washington, or actually pesticide programs across the river in Crystal City, but
Close enough.
close enough, that's right. So it's really important if you're wanting to build a practice and wishing to stay in the Washington area because you're a real policy maven or you really love technical stuff and the intersection of law and policy, these are great statutes to be engaged in because they are not delegated to the states. But as Sheryl will get into a little bit, some states have very mature state programs for the management of pesticides. And another area that we're going to talk about, gosh, we're going to talk about a lot. Another area is the growing movement to the state and even local regulation of some chemicals. And that is in part related to a perception that our federal law, the Toxic Substances Control Act, needs to be modernized and reauthorized because it's 37 years old now and has not been meaningfully amended in almost 4 decades. So those are the two federal key chemical use laws. I don't want to lose sight of the fact that all things in context. There are the laws that I mentioned very briefly that you have heard about other summer programs on, air, water, waste, and so forth. There are also workplace exposure laws that also regulate chemical substances in the workplace. We're not going to talk about that because they're not product laws, but if you're in this space, you need to be mindful of the fact that there are other federal laws and regulations that might regulate the neat chemical in a manufacturing operation or in a transport mode. And the Occupational Safety and Health Administration manages workplace exposures to chemicals. And EPA tends to work closely with OSHA in certain targeted areas that we will mention. Chemical transport laws also regulate chemical substances as they relate to the movement of materials from A to B over interstate highways, and that's the Hazardous Materials Transportation Act. We're not going to talk about that, but you need to be aware of the fact that there's a big, complex array of federal regulatory authorities that are in this space. Other laws affecting chemicals, well, obviously the Consumer Product Safety Improvement Act, TSCA, which came out a couple of years ago, is very targeted on regulating certain chemical substances embedded in consumer products, as that is defined under the Consumer Product Safety Act. Federal Hazardous Substance Act, another law that is regulated by the Consumer Product Safety Commission, and the Hazardous Substances and Household Products. Those are areas that are outside of EPA's jurisdiction, but nonetheless are important to think about as you conceptualize the broader way of federal authorities on chemical substances, whether it's the neat, that's like the pure chemical, whether it's formulated or whether it's embedded in a product, like a consumer product, will dictate often the jurisdictional limits of these acts. Even Homeland Security has a little piece of the action. The Homeland Security Appropriations Act, the Chemical Facility Anti-Terrorism Statutes, or CFATs, these are all federal authorities that have some little piece of the regulation of chemical substances, okay? So with that background, as to the context, let's go into TSCA. TSCA, if a lot of you folks that are aspiring lawyers or policy mavens or whatever may never deal with TSCA at all, because it is a very arcane statute that has a very important place in the role of chemical statutes generally. But not everybody engages in this space. So I'm going to keep this discussion pretty high level. If you are a practicing attorney or aspiring to be one, you might often see TSCA come up in the context of audits. Is a company, is my client, or is a target of our client's acquisition interest compliant with TSCA? So that's one of the main areas where it may come up in your legal career. But a couple of big headlines to remember is, well, what are some of the key terms here? What does TSCA regulate? Well, it regulates chemical. Just trying to find the little. Where is the red?
It's
the laser
on the bottom line, the middle one.
There it is. Okay. Sorry. What does TSCA regulate? Well, it regulates things called chemical substances. What does it not regulate? That's as important to know what it doesn't regulate. Well, it doesn't regulate a mixture. That's chemical substance A mixed with chemical substance B. That mixture is not regulated by TSCA. It's not considered a chemical substance, but the two components are chemical A and chemical B are separately chemical substances, so they are included in. Drugs are not regulated under TSCA. Cosmetics, certain things defined as devices, certainly pesticides. Pesticides are chemical substances, but they're not chemical substances for purposes of TSCA because they reflect or bestow a pesticidal property with respect to both the chemical and how it is marketed. And Cheryl's going to talk about pesticides. So the big line in the sand in our space is generally you're either a pesticide because you reflect some sort of pesticide intent, or you're an industrial chemical. You can be both dependent upon how you're using the chemical. But the chemical substance is a very, very big bucket, and what falls into that bucket is often dependent upon the use of the chemical, okay? As I said, a mixture is any combination of two or more chemical substances, and the mixture per se falls outside the definition of a chemical substance, but remember, the 2 or 3 or 4 or 5 components in the gamish of a mixture are all considered chemical substances. What happens if chemical substance A mixed with chemical substance B forms new chemical substance C? Any of you chemistry majors? Now you probably wouldn't admit it even if you were. But often when chemicals are mixed together, you might form a new chemical substance. So TSCA clearly regulates that new chemical substance that might result from the mixture or the reaction product of two chemical substances. Now, who is subject to TSCA? Okay? Well, the who part is, well, persons that are subject to TSCA include, and principally, again, if you're in this space as a practitioner or policy person, TSCA is often thought in terms of people who manufacture chemical substances, the DuPonts, the Dows, the ExxonMobils of the world, and those who import chemical substances. In other words, if you are a Chinese offshore manufacturer of chemical substance A, when you import it into the United States under TSCA, you are considered a manufacturer of that substance. So manufacturers and importers are pretty much considered the same entity and are definitely subject to TSCA requirements. And a manufacturer is defined as to produce or manufacture in the U.S. or import into the customs territory of the United States. So it really includes a lot of different people. It might also include, in some provisions, processors, people who process chemicals. You're not making them, but you're managing them in a way that is sufficient for purposes of TSCA jurisdiction to draw you into the processor. We'll talk about some of these key provisions here and how they might impact processors of chemicals. So, again, when you're thinking about TSCA and you're in a work context and you have clients, if your client is a chemical producer, you really need to be concerned about TSCA. And after almost 4 decades of this law being in place, that should be a well-recognized fact, but it's not unusual, even today, to have some entities that don't think of themselves as producing chemicals, as therefore, and not necessarily producing toxic chemicals, as being somehow outside the scope of TSCA. Because if you're processing chemicals, you may well be subject to TSCA, so the jurisdictional reach is an important consideration. All right, let's talk about another very important concept under TSCA, and that's the TSCA inventory. When I say inventory, what do you think? What's the first thing that comes to your mind? A long list of something, right? Well, that's what the TSCA inventory is. It is a very long, detailed list of chemical substances that at one point in time, not necessarily currently, but at one point in time were identified as a chemical substance that is in commerce in the United States. Okay, these are, there are about 84,000 and change right now chemical substances listed on the TSCA inventory, which sounds like a lot of stuff. And it is a lot of chemical substances, but recognize that chemicals that are listed on that inventory it does not necessarily mean that they are currently used in commerce. It means they might have been deselected or no longer used, or maybe used for a very short duration and are now fallen into disfavor. So it's a long, long list that contains a lot of stuff many of which are not actually in commerce today. We talk about, if you're in the TSCA space, you will often hear the term grandfathered chemicals. And what that means is they were chemicals that were first identified back in the late 70s when TSCA was signed into law in 1976. And there was a period of time after 76 when the rules started to come out where manufacturers and importers were asked to notify EPA of the existence of a chemical and to provide certain information to EPA. And that's what's populating the so-called initial inventory. And so all of those chemicals, and I don't have any stats on that, but they're probably the majority of chemicals that are now on the TSCA inventory have not been the subject of independent EPA review for purposes of a risk assessment. They are merely vestigial, meaning they were notified by a producer or an importer in the late 70s and were populated on the TSCA inventory. Once a chemical substance, a newer chemical substance, has been notified to EPA, if it wasn't on the original TSCA inventory, it becomes an existing chemical substance on the inventory after EPA has completed the notification process, which we will go through. Could be, as Sheryl indicated, there might have been some 65,000 out of the current 85,000 chemicals listed on the inventory that are newer. And you will hear in the TSCA legislative debate on the Hill right now the big difference between new chemicals and existing chemicals. And the reason for that is there is some concern that the vast majority of chemical substances listed on the TSCA inventory have not been the subject of independent EPA review for purposes of determining whether or not they might pose risks to human health and the environment. It's like, whoa, what's wrong with that picture? And what's wrong with that picture, according to some, is that chemicals that have been used and are currently used in many different applications should be subject to some sort of review to assess the toxicological and human health impacts of these chemicals. So, and as Chandra began our discussion a little bit ago, the European law, the REACH law as it's called, which was implemented a number of years ago, requires that all chemicals, regardless of whether they are new or existing, be subject to independent review by the authorities in Europe. So that's one of the big distinctions between our chemical law and the European chemical law, and the growing number of chemical management schemes around the world that are much more REACH-like, based on the European system of no distinction between new and existing, and our system, which has grandfathered the vast majority of chemicals, and only new chemicals are subject to EPA review. Oops, I'm sorry, I moved. If you can put the full screen back up, I'll promise to behave myself on this.
You can just hit F5.
Okay, stop, right. All right. So remember, there are some big concepts here that I really want everyone in this room to walk away with today, and that is the TSCA inventory is maintained by EPA. It's a long list of chemical substances, about 85,000 now, and the way you get onto the inventory is by submitting a notification to EPA. So what is the difference between a new chemical and an existing chemical? Chemical developers and innovators are coming up with new chemicals all the time. And as you might imagine now, there is a tremendous market incentive to identify newer, greener, more sustainable, less toxic chemicals because they have great appeal for purposes of sustainability, for purposes of market attraction. Consumers like chemicals that are perceived not to be as potentially toxicologically impactful as some of the older chemicals that they're replacing. So there's a lot of innovation going on right now, but one of the big issues in chemical law and policy in the United States is what process you have to abide by to get your new chemical approved or reviewed by EPA. And that's what this new chemical review process is. TSCA Section 5, very important provision, authorizes EPA to review activities associated with the manufacture, processing. I did it again. I'm sorry. I will not play with this thing. Okay, the manufacture, processing, use, and dispose of any new chemical substance unless and until you submit what is called pre-manufacture notification. And that is the most important thing you need to take away from this lecture. If you are a manufacturer and you have a new chemical that you're wanting to replace an existing chemical, or it's just a brand new chemical that has been the subject of years of product development, in order for you to market that chemical, to manufacture it, import it, distribute it, or use it, unless there is an exemption that applies, you have to notify EPA of your interest in doing that. And for new chemical innovators, that's not great news. You've got this brand new chemical that is fabulous in your mind, and it's taken 20 years and $15 million to develop. What's the first thing you want to do? You want to sell it. You want to have it embedded in products. You want to be able to make money on your innovation. What TSCA Section 5 says is, hold the phone. Before you do that, you have to submit a form to EPA called a pre-manufacture notification, submit it to EPA, and EPA has to review various aspects of that new chemical to ensure that it meets a certain safety standard for uses for which that chemical will be applied. So it's not an approval statute per se, it's a chemical notification requirement. That's why it's called a pre-manufacture notification. So the PMN form itself is not very long. You can go to the EPA website and pull it off, but you are required to submit the name of the chemical, expected uses and applications, the chemical structure. If you have any toxicological or other data associated with that chemical, you are required to submit it to EPA. You're not required to develop new data, which is, again, another issue that has been associated with a deficiency of the current chemical safety law. The agency has authority to compel the production of new information, but not as a predicate to submitting a PMN. It's merely notification. So what happens when you submit the PMN? Under the law, EPA and the men and women and the professionals at EPA have 90 days to review that notification and make a thumbs up, thumbs down determination as to whether it is going to pass the various screens that the agency has to weed out chemicals that might pose risks that are perceived to be unreasonable, okay? 90 days is not a lot of time. So what EPA does, especially with respect to chemical substances that there are no new data associated with it, and again, you're not required to submit tox data with new chemicals. So what EPA does is apply a number of very sophisticated models to assess whether the toxicological properties and chemical formula of a particular new chemical substance correlate with chemicals for which the agency has information, and it applies what is called structural activity relationship models to determine whether or not your new chemical is going to pose risk to human health and the environment. And that's a standard against which the agency is required to assess new chemicals, to suppose unreasonable risks. So if the PMN is pretty clean, the agency goes through its processes, and by the 89th or 88th day, you don't hear from EPA, you don't get a phone call or an email saying, Houston, we have a problem, you can pretty much assume that the PMN has been officially notified and processed for EPA, and it's available for use. But that process is extremely important, and for any of the newer chemistries coming out today, it is not unheard of that maybe in the 40th, 50th day or through the beginning part of the agency screening process, you might get a phone call or an email from the EPA that is starting to ask questions, which from a chemical producer's perspective is not welcome news. It usually means that there might be something with that chemical that is causing EPA to express some concern about its use sites, or something that might give rise to a delay in your ability as a manufacturer to use and sell that product. So again, how many of you are in the business community? you got a brand new chemical and you're really anxious to get it out and to sell it, that's a big hard stop. And so you have every incentive to work with EPA to provide whatever information the agency is seeking to get that much needed approval so you can begin to sell your product. EPA has the ability to suspend the 90-day period. So although the law requires that PMNs be reviewed within 90 days of submission, that 90 days can turn into 120, 200. We've had PMNs through the process that have gone well into the multiple year review, because you want to keep suspending that deadline so the agency can come to a favorable resolution, okay? Once, let's say you don't hear from EPA, everything is fine, what actually gets your chemical substance, the CAS number, the chemical identifier number on the magical TSCA inventory that enables you to say that you have an existing chemical substance, is a submission of a notice of commencement. So once you submit the NOC, that new chemical substance becomes an existing chemical substance and is added to the TSCA inventory. So there are a lot of chemical substances, maybe 20,000 or so, that have been added to the inventory since it first came out in the late 70s. And that's why you now have 85,000 chemicals as opposed to the 65,000 or so back in the late 70s. It's no longer considered a new chemical, it's an existing chemical substance, and life is great. So as I said, we now know it's close to 85,000 on the TSCA inventory, and whether you're on or off is the big magic line in the sand to determine whether you're a new or existing substance. Okay, so once you are considered an existing chemical substances, and now we're moving into EPA's record-keeping and reporting obligations, because this is very important also from a compliance perspective. Where are the big areas where EPA gets chemical importers and manufacturers and others subject to TSCA? The record-keeping, reporting requirements, and determinations as to whether you are manufacturing, using, or distributing a chemical substance that is not properly identified on the TSCA inventory. Because if you are manufacturing, using, or distributing a chemical substance that is not listed on the TSCA inventory and is not subject to an exemption, your client has problems, because that is one of the #1 big-time enforcement areas for EPA, is the manufacture, distribution, and use of a chemical substance that is neither exempt from TSCA, nor is it listed on the TSCA inventory. And I neglected to add that there are actually, just to make your lives completely miserable, 2 inventories. There's the public inventory that you can go to the EPA website and click on and have access to the public inventory, and then a super secret private inventory, the confidential inventory, which is very important. You know, people don't want their pixie dust necessarily shared with the world, because that might give them a competitive edge. It might be stolen by other companies, offshore companies. Very, very important. CBI, confidential business information, is a very important topic for EPA, and they do a great job of managing information carefully. But what happens if you're trying to determine if a chemical substance is listed on the inventory so you can use it? And think of it, you got 2 inventories, a public one and a private one. How do you determine whether or not your chemical substance that you want to import into the United States is lawful to import? Well, you just said, Lynn, you look at the TSCA inventory, and if it's on the inventory, it's approved for use and you're good to go. But what about this private inventory? Well, there's a process that you can use, it's called a bona fide intent. You tell EPA what the chemical is, and you say you have a legitimate business interest of importing or manufacturing this chemical soon, I think it's 30 or 90 days of that wish. And then the agency, to submit that form to EPA will tell you, don't worry about it, it's on the super secret inventory, so you don't have to submit a new chemical notification under TSCA Section 5. Or you do. So there are lots of bells and whistles to TSCA, but I guess one of the important takeaways is the public inventory and the private inventory to preserve confidential business information. So EPA has vast authority under TSCA to compel the production of information, and all of these data reporting obligations are really important, not just for purposes of compliance with TSCA, but to me they're also important for purposes of chemical producers, manufacturers, and processors to start looking at kind of a trends analysis as to whether their product that might contain a chemical substance or the chemical substance they are making might give rise to adverse health or environmental effects, such that you should be tracking that as a product steward to ensure you're not hurting people. I mean, chemicals are needed, chemicals are essential, but chemicals need to be handled with care. So a lot of these reporting requirements are not just relating to TSCA compliance, but they enable you to determine, am I doing something that my customers are calling me saying I got a rash, for example. C8C, allegations. Companies must retain allegations of adverse effects and submit them to EPA upon request. So you have to have a file that maintains allegations of adverse health effects, and if EPA asks for that, you're required to submit it. But in addition to just compiling this information for TSCA purposes, it's a very important way of tracking whether or not one of your chemical products is giving rise to an adverse effect. So we encourage our clients not just to keep a drop file and deal with this silly record-keeping requirement, but to be very mindful of what's going in there so you can avert any potential toxic tort liability outside of TSCA if your product is giving rise to effects that you knew or should have known could be and should be addressed outside of the TSCA context, and just because you're a good product steward. EPA also has this authority under TSCA Section 8A. It's a cyclical reporting requirement called the Chemical Data Reporting Rule, which was revised extensively a number of years ago, and now requires companies every 4 years to submit product production, use, exposure information on substances over a certain threshold requirement, which is 25,000 pounds per site per chemical. So that's one way EPA gathers a lot of information on chemicals in the stream of commerce that are being imported and used, and where these chemicals are being embedded, and what populations are being subject to exposures from these chemicals. So it's extremely, very, very important reporting obligation. At TSCA 8E, at the end of the line there, companies must immediately, and the EPA takes this very, very seriously, report information regarding adverse effects of a chemical substance. There's a parallel reporting requirement under FIFRA that Sheryl will get into, but not surprisingly, if you are a chemical manufacturer or importer and you have a new toxicological report that shows a new adverse effect that heretofore was not known to you, maybe an exposure at a different dose rate, for example, or at a higher number of mice in a particular study succumb to a particular adverse effect, that information must be reported immediately to EPA, which is 30 days, within 30 days, calendar days, not business days. So 15 is quick.
It's a very short period, especially if a company doesn't have an existing plan, program, procedure for getting it done.
And some of the largest enforcement actions on the books relate to failure to report, because this is one of the reporting mechanisms that EPA takes very seriously, because it provides an immediate means of identifying adverse effects information and addressing it quickly. So there are lots and lots of law litigation over what is and is not reportable. There are certain exemptions to the reporting requirements. By and large, our philosophy is if people are struggling over whether or not it is truly reportable under TSCA Section 8E, our view is go ahead and report it, because that way you discharge your reporting obligations, and if EPA disagrees that it was reportable, it doesn't matter. You've covered your obligations and you can move on. So what happens with EPA, and the logic of TSCA is that it's this cascading kind of series of very elegant reporting requirements. We talked about the inventory. We talked about getting chemicals listed on the inventory and the reporting obligations for new chemicals. EPA has all of these opportunities to procure information regarding existing chemicals that it can exercise cyclically, as in the case of the chemical data reporting obligation, or more episodically, as is the case with an 8E. EPA has under 8A authority to compel the submission of information based on its belief that it needs information for one reason or another. Well, what does it do with this information? Well, EPA reviews the information, and it might determine that it lacks sufficient information to make an informed judgment as to whether or not a particular chemical or a particular application of a chemical might pose unreasonable risk. And that's when EPA might think about issuing a TSCA Section 4 test rule, which gives EPA authority to require, again, principally manufacturers and importers of chemical substances to conduct testing on specified chemicals. And in the 80s and 90s, there were lots of what are called TSCA test rules. And again, these are very unwelcome pieces of news for chemical manufacturers because these test rules are very costly. They often will require chemical toxicological testing for multiple endpoints, a cancer bioassay, which is usually well in excess of $1 million, a couple of million, neurotoxicity testing, dermal testing, developmental reproductive toxicity testing. So the battery of chemical tests that chemical manufacturers and importers are subject to could be $5, $6, $7 million. And typically what happens is whoever is producing the chemical or importing the chemical will join together in a testing consortia, divvy up the cost either on a per capita basis or a nameplate production capacity basis, submit that information to EPA, discharge their testing obligations under TSCA, and one hopes move on. What's the last thing you want to have happen, though, when you do this testing and you get a bit of adverse information you didn't anticipate? So you're president of Dow Chemical Company. You've just completed $10 million worth of testing for reproductive toxicity effects on one of your, rock star chemicals. And you find out that this chemical might pose a reproductive risk at a level that might be at or exceeds an exposure level that is apparent in your normal processing and distribution use patterns. What do you say? Oh, sugar, this is not great news. What does it invite? It invites product concerns. It invites the potential for tort liability. It invites product reformulation opportunities. It invites a whole cascading series of business and legal considerations that TSCA Section 4 was exactly intended to elicit. Because if there's a chemical that's being used out there in a product, whether it's a floor cleaner or a paint or materials in construction, and then if you're finding that it's off-gassing or giving rise to an adverse human health effect at levels that are likely to be encountered by unprotected consumers, we need to know that. And that's exactly why TSCA Section 4 was created. But just think in the context of what does that invite if you have adverse effects information. I've got about 200 chemicals tested through this TSCA Section 4 program over the years. Now, you might think, well, wait a minute. Didn't you just say there were 85,000 chemicals on the inventory? Does that mean there have only been 200 chemicals subject to TSCA Section 4? What is EPA up to? Well, that's a very misleading number one, because there is all kinds of other testing that has been going on through voluntary programs like the High Production Volume Program, Children's Protection Programs, voluntary testing. And I don't want you or anybody in this room to leave this lecture with the thought that chemical producers don't test their chemicals, because nothing could be further from the truth. You don't get to market a chemical unless you have a very high confidence that your chemical is going to perform as intended safely. And why do you think that is? Because we live in the United States. You sneeze and somebody might file a lawsuit over it, right? An adverse chemical reaction. So you have had a very high confidence level that your product is not going to hurt anybody. So when EPA engages in Section 4 testing, it's usually for a very specific adverse health effect that, based on all those other test rulemaking and record-keeping obligations, EPA has teased out something that they want to know further about, okay? So, getting back to our big, elegant construct for TSCA. We have the TSCA inventory, got all these record-keeping data, maintenance obligations. Section 4 gives EPA the authority to sniff around and test. When the testing is done and there are no adverse effects, life goes on. But what if there are concerns? As I said, there are concerns that after testing and information management, EPA needs to do something. Again, this is an area that is not welcome news for the chemical manufacturing community. Because you've got this rock star chemical product, you're making all kinds of money on it. EPA engages in a Section 4 test rule, and oops, an adverse health effect is teased out of it. Now what happens? Does EPA ignore that information? What do you think EPA does with it? You're the assistant administrator for the toxics division at EPA, and your staff has just told you that after 3 years of chemical testing, hexylmethyl whatever causes dermal effects in a way that no one anticipated. So you're the assistant administrator at EPA and the toxics. What do you think you have the authority to do under TSCA? So it's very intuitive. Go ahead.
You have the authority to limit limit new uses of it, and limit new, existing uses are harder to do. But you can limit
Exactly, but this brilliant person has just said, well, there are probably opportunities to limit exposure, to require the application of labeling requirements, to deselect certain uses that might give rise to risk. The TSCA Section 6 authorizes lots of different authorities to EPA. Risk management options that include labeling, record keeping, use restrictions, bans. Remember, EPA tried to ban asbestos a number of years ago and failed, and that gave rise to this corrosion-proof fittings case, a Fifth Circuit Court of Appeals decision. And there has been, in the more recent TSCA debate, concerns about whether the legal standard that EPA must follow to ban a chemical or use of a chemical is too stringent. But there's lots of discourse on that. I, for one, don't think the ban requirements are too stringent, but it is true that the agency has had difficulty banning chemicals over the years based on the TSCA Section 6 authority. But the 5 substances that have been restricted under TSCA 6 over the years reflects the fact that, you know, it can work. It's just a very high legal burden, and chances are with TSCA modernization legislation, the TSCA Section 6 risk mitigation measures and the legal threshold for inviting those measures will probably be revised. That's that last line there, asbestos court decision flagged as an indication that Section 6 does not work. That is one of the recurring themes in the TSCA reform debate, that Section 6 is way too strict, and if you can't ban asbestos, what the heck can you ban? So, let's talk a little bit about what the concerns are with the current TSCA system. Well, one is just the perception, and not unreasonably so, that after 37 years, which is probably older than most of you, this law has never been amended. And look at the advances we have in chemical production over the years. We've gone from chemicals based largely on the petrochemical feedstock, petrochemical synthetic chemicals that became very popular after World War II through the 50s and 60s. We now have nanoscale materials that are the result of nanotechnology. We have bio-based chemicals, chemicals derived from naturally occurring feedstocks to replace petrochemical feedstock-based chemicals. So we have this really revolution in the production of chemicals, but our chemical law has been largely unchanged for 37 years. So there is concern that that alone, you know, you had me at hello. We've got to change this because it's way old. But in addition to that, there's great concern with the fact that there is no requirement that entities notifying EPA of new chemicals submit data with that. Under the European system and under systems that are cropping up around the world, the Canadian system, K-REACH in Korea. Korea is going through a chemical renaissance as we speak. All of these programs require the submission of what is called a minimum data set. Certain information that will give you just the basics on whether or not this chemical is likely to pose adverse effects and perform safely as intended, okay? There's no minimum data set required for existing chemicals. There's no minimum data set required for new chemicals. As I said, when you submit a notification, you're not required to submit information unless it's existent. but you're not required to develop new data. There's concern that too few chemicals are tested under TSCA Section 4. And in large part, the TSCA Section 4 provisions for those lawyers in the crowd, if you're really interested in this area, there are many different cases as to what the legal burden is and whether EPA met certain legal findings sufficient to authorize EPA to compel the production of costly toxicological or environmental phase testing. So this is just a legal wonderland that has given rise to lots and lots of litigation, but not a lot of testing. That too few chemicals are regulated under Section 6, which is true, not a lot have. And that they're too easy to claim confidential business information. Anybody submitting information to EPA is going to be very cautious about what it discloses publicly. We live in a very transparent society. EPA, as I said, does an excellent job of maintaining your corporate secrets. But with the community right to know train moving in this direction, and proprietary business interest and not telling anybody what your pixie dust is moving in this direction, you get the inevitable collision of competing public policies. So right to know and needing to know what's in a product, what chemicals you're being exposed to, that's important. But do you need to know the exact chemical substance and how it's formulated and what makes your product special? No. And so EPA struggles with how to address these competing public interests, and it's not easy. But in the more recent past, EPA has done much more to keep people on the straight and narrow in claiming information as confidential than before. And I will be the first to admit, I think the chemical community in years past has used the CBI election much too liberally. Now EPA is thinking about requiring upfront corroboration of your CBI claims to ensure that if you're going to claim something as confidential, it sure as heck better be really confidential and meet the pretty rigid standard under the rules of what qualifies as CBI. So where are we at right now? Well, we've been talking about TSCA modernization, I think, since I was in preschool. There have just been so many discussions, so many legislative initiatives to modernize TSCA, but in this particular Congress, up until recently, I thought it was like, no way. The House and Senate Republicans and Democrats can't agree on the time of day, let alone how to modernize a very complicated, very important federal law that represents the intersection of policy, science, regulation, competitive interests, you name it. I mean, if you want to do a drama or have a reality TV show, it would be all about TSCA reform. I think I'm going to do that. Starring. Anyway, 2010 we had the Safe Chemicals Act that Senator Lautenberg, the recently deceased, very sad passing of Frank Lautenberg from New Jersey. He has been a champion of TSCA reform for years, and he really wanted to make it his legacy to modernize TSCA before he left this earth. He reintroduced it in 2011. He even reintroduced a similar version of that in April of this year. Senate Bill 696, which was modified in very significant ways from prior iterations. And we have very extensive analyses of all of these bills on our website, which are there for, we have a very content-oriented website, so we have very significant analyses of how the 2013 version of the SCA reflected profound differences in prior iterations that reflected Senator Lautenberg's desire to make something work, to make something with the Republican minority in the Senate and majority in the House. Let's try to get something going, but that didn't work. So much to our infinite amazement, at least it was me, I was amazed. On May 22nd of this year, Senator Vitter, the Republican from Louisiana, and Senator Lautenberg introduced a jointly sponsored Chemical Safety Improvement Act, S1009, with some 20 different bipartisan co-sponsors. I mean, you couldn't push me over with a feather, because seeing Vitter and Lautenberg in the same snapshot on their websites was something I never thought I would see. But it's a reflection of Senator Vitter's interest in moving forward with TSCA reform and Senator Lautenberg's desire to have his legacy realized. So when it came out, you know, there was all kinds of kumbaya-ing all around the world. Like, oh my God, the environmental defense kind of endorsed it. Environmental working groups said not only no, but hell no. There were House and Senate entities that separately expressed both their enthusiasm over what seemed to be the beginning of a bipartisan consensus on TSCA reform after all these years. It was really, really, really cool, but the honeymoon is definitely over. Definitely over. Barbara Boxer is chair of the all-important Senate Environment and Public Works Committee, and what do you think Senator Boxer's view is? A, she didn't know about this. B, she's chair of the Senate EPW committee and had no clue this thing was popping out. And there are very significant preemption provisions in 1009, which basically, under some circumstances, it would immediately and prospectively preempt state chemical regulatory regimes.
California.
Yes, so you just think California Prop 65, the soon-to-be issued Safer Consumer Product Regulations, which has been a work in progress in California for the last 5 years. There have been 9 separate iterations of public comment on that. Really important stuff. And I think EPA and most of us thinking human beings admire what goes on in California as precedent-setting legislation that EPA has relied upon, certainly in the VOC context. And I think EPA is looking very closely from a design for the environment and greener, safer chemicals perspective on what's going on in California for its alternatives assessment. So California is to be complimented on what it's doing, not written out of the script, as, you know, 1009 might do in some respects. So Senator Boxer has not scheduled any hearings on this and claims that she will not bring it up until certain amendments are made, largely to the preemption provisions. There is a hearing scheduled on July the 31st on a spate of federal environmental statutes, which I understand one of them is 1009. So for all of you policy wonks that want to go up and look at a hearing, and Julia, you will be at that hearing. Julia is our summer intern. That will be a very exciting, and I know I need to get a life, but I think this is going to be a very exciting hearing with Senator Boxer there at the helm and telling us what her thoughts are on 1009. Now that's on the legislative side. Where does EPA? You guys are with EPA. Where does EPA stand on TSCA reform? No comment. No comment. The administration hasn't really, I think the administration is very supportive of TSCA reform, but hasn't articulated any particular view with respect to 1009 or any of the predecessor versions. The House, I might add, had a hearing on June 13th, not on any particular legislative vehicle, but that the House of Representatives, a vast majority of which are new members and probably couldn't pick TSCA out of a lineup of other operas, held a hearing on TSCA generally, and our colleague Kathleen Roberts testified at that hearing to talk about the fundamentals of TSCA, and it went very well. And Senator Shimkus, a Republican from Illinois, expressed interest in entertaining TSCA reform legislation in the House. So another little bit of information that's good news. If we want to see TSCA reform before some of us die, and for me, that's going to be before you guys, but for you, younger people that really want to lead the world in a way that's better than you found it, you should want TSCA reform too. So get out there and keep your legislators focused on TSCA reform. Just a real quick overview of some real key regulatory developments, because what do you think EPA is doing? Well, TSCA, this ancient statute, in its dotage, you know, teeters on to move forward. Well, EPA has been very energetic over the last, I think, well, when did Obama get elected? Very energetic over the past, certainly 5, 6, 7 years in thinking of new and different ways that TSCA can be used to achieve some of its goals and address some of these deficiencies that I addressed in my remarks. So TSCA has, or EPA has developed this TSCA chemical list of concern. It has prepared action plans on this long list of chemicals that are known to pose certain adverse effects under certain conditions and certain use sites. These action plans identify a whole series of administrative actions that EPA has or is considering taking based on its review of these chemicals. EPA has more recently identified work plans, and if you get the sense that the agency is struggling to kind of get the right vehicle, you're absolutely right. I mean, some of this is the passage of time, changes in leadership in the White House, changes in leadership at EPA. Jim Jones is the current acting assistant administrator of the Toxics Division. He moved over from the pesticide office, pesticides that Sheryl's going to be addressing momentarily. So Jim has a very clear understanding of what he would like to see done with respect to industrial chemicals. He would like them reviewed for their risk in a way that is not unlike his pedigree in the pesticide office. So the new TSCA work plan, EPA in March of last year identified some 83 chemicals that it put the regulatory community on notice that it would be engaging in a risk assessment process with respect to these chemicals to determine whether EPA needed to deploy any of its tools under TSCA to limit, address, or blunt potential risks. So we're in 2012, EPA, I think, really finished 5 of the 7, and 2 have not. There have been proposed rules under TSCA to impose either new labeling or new risk assessment measures on 5 of the 7, first out of the chute of the 87 or 83 that have been identified for EPA review. Okay. So these work plan chemicals, I'm not going to go through this, it's in your materials, but it gives you a sense of what some of the chemicals are and what some of the measures are that EPA has identified. And some of these are very, very recent. EPA's focus, not surprisingly, is on chemicals that are embedded in products that are sold to consumers. Because why? Consumers are the most unprotected population out there. Workers have workplace controls and institutional controls and personal protective clothing and equipment measures. And, consumers take chemicals and use them without any type of respiratory, dermal, usually. I mean, some chemicals do urge you to use gloves and so forth, but that's...
They all read the label thoroughly.
Well, I think I read the label, but, do you read labels? Do you go down the aisle and... Yeah, I think so, because you don't want to, if you smell something that's particularly pungent or if something touches your skin and it burns, it's pretty good to read that little label. But not everybody does. Cheryl's exactly right. As I mentioned before, the chemical data reporting rule, EPA issued very significant amendments to it a year before last, and the first reporting cycle that came in requiring all of these new data fields to be populated was about a year ago, 10 months ago or so, August 13th, and EPA has reviewed those data. And that's another data point that the agency will look at to determine whether or not it should be prioritized for review, whether new limitations should be imposed on it. So if you're a chemical producer, or if you represent a chemical company, you really want to be aware of what's in this publicly available database with respect to chemicals that are important to you. I don't have a lot of sympathy for companies that come to me and say, oh, Lynn, I didn't realize that this TSCA rule is going to come out limiting half of my market and inviting all types of product liability concerns. It's like, well, dude, did you look at what's in the chemical data reporting rule? Are you looking at what's in your 8A, 8C reporting obligations? These are the things you need to be focusing on as a product steward. And this is another data point that should be mined and harvested and reviewed carefully, so you get a sense of where EPA's thinking might go. Also, new rules on CBI. As I said, EPA is much more circumspect, and the business community is much more focused now on asserting that confidential business information claim only on pieces of information that are truly deserving of protection. Because I know often we are asked to kind of do, gee, is this all right? Can I claim this is confidential? And then we'll Google the company's website, and there's a material safety data sheet containing the CBI information. It's like, ay, ay, ay. If it's on the internet, dude, it's not CBI. You've blown. And if you think for a minute that EPA doesn't look at Google searches and other publicly available, I'm looking at you, EPA, other publicly available sources of information, of course they do. So, you gotta use your head and only assert CBI for things that are truly super secret. Boy. Okay, what are some of the big challenges, I think, that are not in the PowerPoint? I think there is right now real concern with the drain on some of the really expert people that have been at EPA for many years. I know we are concerned about the great diaspora of people are, of retirement age, being wooed to private practice. With the hiring freezes and salary freezes, it can be discouraging to work for a federal government and maintain your enthusiasm for being a committed steward of the environment when you haven't had a raise for 3 years. Where EPA is now under sequestration limitations. You get another day coming up over the July 4th holiday where people have to go home, turn their Blackberries off, not look at their computers, not do anything, which simply makes you further behind in all the things you're supposed to be doing. So my sense is that it's just a very dispirited atmosphere sometimes, and not just EPA, but in federal agencies generally. And it's a very regrettable consequence of our Congress's inability to do just about anything, but most importantly, give federal agencies the resources they need to do their job. So you have a lot of people that grew up with EPA when it was created and are now of retirement age. Those positions are not being filled. You have people coming up the ranks, but there's a great deal of expertise that is migrating away. For those of us that have been doing this for over 2 decades, it's a significant concern. Plus, we would just like to see EPA happier, more resourced, and able to do the very extraordinary things that it's capable of doing and needs to do under the important burdens of TSCA and FIFRA law and policy. And TSCA reauthorization, if this doesn't happen this year, my own particular view is that it ain't going to happen as we get near midterm elections next year. It's already a very toxic environment on Capitol Hill. And so if 1009 and some companion House version isn't introduced sometime pretty soon, I don't have a lot of hope that we will be able to broker a deal. And there is now, as I said, the honeymoon on 1009 is a little bit over, and partners are beginning to snipe a little bit over which way the marriage ought to be headed. So I don't know where that's going to go. And on some of these regulatory programs, with House Republicans in particular, there's been a lot of oversight hearings on whether or not EPA is deploying its resources well or misdirecting them in terms of the chemical work plan approach versus the chemical action plan approach versus this or that. Part of the lack of a clear focus on chemical management is a function of the law itself. TSCA doesn't give any sense of a particular strategy or priority. It's for EPA to, kind of intuit. And when you have multiple administrators, multiple administrations over the past 37 years or so, it has caused some disarray in deploying resources in a way that is efficient, outcome determinative, and fully able to discharge what was behind Congress's intent when it implemented the law. So those are just a couple of the big picture concepts, regulatory initiatives, legislative challenges, and where TSCA falls in the grand scheme of the federal family of laws. And I'd be happy to answer the many questions that I know you have. And on the phone.
Yeah. And please wait for the microphone before you ask questions. Thank you.
Yes, we have a question.
A question on risk reporting. So what is the incentive, for a large chemical company that's doing all their testing in-house, theoretically no one else has access to the information except them. Other than the prospect of someone undertaking independent testing of their substance and saying to EPA, hey, we found this out about this chemical, what's their incentive to report, a significant risk that they have if they have found one?
Okay, very good question. The question is, what incentive is there for companies that engage in testing to report timely their obligations under presumably TSCA Section 8E? Because that's the adverse effects reporting requirement that people are required to report to EPA immediately, if not sooner, any adverse effect. And the answer is the failure of doing so timely or at all will give rise to significant enforcement consequences. As I noted in the DuPont case, that was one of the largest violations in civil, in a civil context of some well in excess of $1 million. I don't know if it was a multiple millions, but multiple millions of dollars. And when a big company is subject to a public rebuke like that, it's not just, oh wow, we have to pay this, because the financial consequence is not terribly burdensome. It's the reputational damage. It's the shareholder concerns. It's like, well, wait a minute, leadership at the top, where were you? Might their people be losing their jobs? So there are lots and lots of adverse consequences that flow from an enforcement action that companies really wish to avoid. But I personally think, given our work for the chemical community for many, many years, the desire is not motivated by fear of consequence for not doing something. Rather, I think most chemical companies are very interested in sharing information they know the agency needs to know in order to make informed judgments about the regulatory status of that chemical. So it's fear of reprisal, but it's also doing the right thing, knowing that that's the right thing to do, and taking prompt, immediate steps to abate a risk that might pose a public health risk if left unaddressed. And there are criminal penalties as well. TSCA has administrative, civil, and criminal, which can result in incarceration and all types of other consequences for corporations that are subject to criminal liability. Did you want to add anything?
Well, I was just going to say, yes, criminal penalties for knowing violations, so hopefully that would get the attention of executives.
Right. I mean, Club Fed is not what it's cracked up to be. Nobody looks good in an orange jumpsuit. So those are important consequences.
And there's a matrix for the penalties, and 80 is at the top of the matrix, and failure to report is considered to be a very serious violation, so that would accrue penalties most quickly.
Is the president of Dow Chemical has a question?
Can I just ask
follow-up question? Okay, one more, that's it.
So in that DuPont case, I came in a little late, so I'm going to miss this. How did it come to light to the agency that this data existed, that there was this significant risk and that the company knew about it?
I think in that particular, the question is, how did it come to light that information that should have been reported in EPA's view was not? Very good question, very complicated fact pattern. There's very significant debate. In fact, we wrote an article on this on our website. If you go to our website under published articles and look for TSCA and then put in DuPont and AE reporting, you will see that there was very strenuous debate as to whether or not these effects that had to do with the presence of a contaminant in groundwater in West Virginia, relating to a very high-profile kind of rock star chemical, PFOA, a perfluorinated chemical, was giving to potential adverse consequences for people that were impacted by the groundwater. So there's a very robust debate as to whether it in fact rose to the occasion of a reporting event, but because DuPont, being the very stellar corporate citizen as it is, chose to just settle out with EPA. But the information came in the context of other collateral tort litigation pertinent to that molecule in that community. And that's often the way this information comes. It's not like EPA has an army of hundreds of inspectors to go out and knock on every chemical door in the country, because it doesn't. It's one of the consequences of a diminished budget. So a lot of this stuff comes in through competitive issues. Competitors will call and report anonymously that hexylmethyl pixie dust was found over here, and you really ought to go check it out. It might come in the form of an employee expressing concern about test results that he or she believes were not timely reported. Or it might come in the context of discovery, litigation papers, where people start looking at, well, wait a minute, you should have reported this 10 years ago. This is important stuff. And then it gets reported up to EPA, and then EPA might be of the view that, yes, it should have been reported, and what are the consequences for doing so? So that's how that's how that particular local litigation gave rise to that information. Now, President Dow.
How do companies protect their interests when they're in the research and development phase of a new chemical? Like the one where the example you gave, they spent $10 million testing it and then found something. Like, do they have insurance policies, or like, how do they not
Go under
when they're researching?
Well, that's a very good question, and because of the brevity of this presentation, I didn't go into the granular details of exemptions from notification, one of which is the research and development exemption from notification under TSCA Section 5. So you don't have to report to EPA, and you can engage in R&D activities, which includes the sale of your pixie dust, You can do that lawfully. But what happens if you have an R&D chemical and it gives rise to some adverse consequence? Yeah, you would look to your private remedy of either whatever agreement you have with the recipient of that information, that it knew or should have known that you had to manage it according to whatever product spec sheet that you have developed, and if they didn't do that, then you would claim that they're liable for the consequences of their misapplication or misuse, and then the parties would just bring in their primary, secondary, and subrogation agents to duke it out. If it became the subject of a enforcement action, then again, private remedies would kick in. The manufacturer of the chemical would be on the hook, but then that entity could try to get its claim addressed by the entity that might have given rise to the harm if they misused it or used a chemical in a way that was contrary to the manufacturer's direction. So those types of protections are both business, and they might involve an element of public notoriety through an administrative or civil action. So I would say private remedies. That's how they try to protect themselves. But again, small startups, we do a lot of work for small startups. Chemical companies that are very innovative, do a lot of work with the nano community. You talk about high risk. You got a quantum dot or a carbon nanotube. You want to go manufacture it because it has terrific new chemical properties, strengths, tensile, whatever the magic pixie dust is. It has enormous commercial application, but there's tremendous speculation about whether certain CNTs might give rise to certain adverse health effects under certain conditions, inhalation risk. So you have to immunize yourself in a way that is smart, through insurance, through very tight contracts, through very descriptive product spec sheets, and trying to mask the fact that a chemical is actually being manufactured, sold at the nanoscale, and calling it carbon is not a good idea to me. And some would argue that you have an obligation to disclose more information, not under TSCA, but under the OSHA Hazard Communication Standard. So again, we began this discussion with recognizing that there are other collateral points that you need to be mindful of if you are in this space counseling clients or counseling the company that you work for on what your obligations are. And it's always a good idea to disclose as much information as possible smartly and be as product stewardship minded as possible. Know the law, know the rules, and if you don't know that, you shouldn't be in the chemical space because you're going to have just a lot of heartache if you don't know what you're doing. I think, okay, one final question? Yes, and then I'm going to turn it over to Fifferland.
So my question relates to the EU REACH program and the differences. I think under the EU REACH program there's a lot of chemicals that have been banned for sale and manufacture in the European Union. And so I was wondering, what is the difference between the 5 chemicals that were banned here and I think it's like in the hundreds of chemicals that were banned in the European Union? Is there any exchange of information about the hazardous impacts of chemicals that are banned in the European Union and not banned here? Like, what does the EPA does the EPA use international resources and international studies? And I guess also
that's your question. No.
The question I guess is about, does the EPA use the international resources, or is it a different standard? Does the EPA just have higher allowances or higher thresholds for impacts than the European Union?
Okay, great questions. And I'm going to try to distill it to a couple of points. Number one, there are, under the European system, the REACH program, which was implemented a number of years ago. There's been a lot of information required under that program, and all of that information is largely publicly available. So the question is, does EPA take advantage of the new information derivative of this preparation of certain dossiers, chemical profiles that address certain guideline requirements under the European law? The answer is absolutely. And even if EPA didn't, we live in a very transparent world. And so when chemicals are thought to pose risks and are identified as risky chemicals under the European program and put on what is called the SVHC, the Substances of Very High Concern list in Europe, it has an immediate impact on what goes on here. Very important to, should I get this? Well, you can do it. So the interplay between the optics of a chemical and how they are being investigated under other programs that are thought to be more robust and more granular than our program is having a very significant impact on the profiling of chemicals here and even on EPA's identification of priorities for purposes of review. And the information is publicly available. All of the REACH information is on a database, and you can go in and access that information, except for information legitimate claimed as confidential. And how those data are managed and the various groups that participate in the development of a dossier often spend a lot of time ensuring that their communication of that information is done not just in the European Union, but done in a way that anticipates global information distribution about those dossiers. I mean, data is the new currency of the world. And if data are produced, whether existent or new, and put in a risk assessment in Europe or in South America or in Canada or in Korea or China, that information is known immediately. And so, excellent question. My very short answer is it has very public, very significant impact, and it is served to highlight some of these significant differences between the European system, which covers all new and existing chemicals, and they all are prioritized, and they all have to go through a chemical review assessment phase. And if they don't pass, they get nominated for this substances of very high concern. And once you're on that SVHC list, you think you can market a chemical here in the United States as easily as before when it's been identified by the European community as a substance of very high concern? What do you think? It has immediate impacts here. So the world is a small place, it's getting smaller by the day, and chemical programs are having a very significant impact on the United States marketing of chemicals, which is another reason why we really ought to be imploring our legislative bodies to modernize TSCA, or it will simply become an irrelevant artifact of the distant year gone by. And with that, in deference to my colleague, who now has only 40 minutes to go through a very important law, I'm going to stop and then thank you all very much for your attention and leave. Bye.
Unlike Lynn, I'm not a pacer, so I'm not necessarily going to, although I will stand if you can't hear me, but if anyone needs a 7th-inning stretch for just a moment, I'm going to get some more, or attempt to. Okay, to continue this conversation on product regulation, we're going to talk about the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. FIFRA sets the legal framework for the regulation of pesticides, which, as we'll discuss, is a little bit broader than insecticides, fungicides, and rodenticides. The federal government has been regulating pesticides since 1910. FIFRA has been in its current format since 1972, although it's been amended, unlike TSCA, it's been amended substantially several times since then. FIFRA is basically a licensing statute. It is a violation of federal law to sell or distribute an unregistered pesticide that's subject to FIFRA and not eligible for an exemption. It's unregistered, as I said in there. So any product before it's introduced to market has to be the subject of an application to EPA and undergo EPA review. Let's see if I can avoid Lynn's problems with this. Yeah, and no, there we go. As mentioned, EPA is the federal regulatory agency that has the implementation authority for FIFRA. The very aptly named Office of Pesticide Programs implements the program. It's a complex program. There's a lot of considerations. So there are a lot of divisions within OPP. They can be grouped, sort of by their function. There are the regulatory divisions that do registration work that include, again, the very literal, aptly named registration division. Pretty much all conventional pesticides are regulated through RD, except for those that are either antimicrobial products. So your products that are, for example, like hard surface sanitizers, disinfectants, or products that fit into the biopesticides category, which is handled by BPDD, or Biopesticides and Pollution Prevention Division. FIFRA and OPP's work is very science-rich, data-rich. So there are science-focused divisions as well that do a lot of the risk assessments, basically. So that includes the Health Effects Division that focuses on human health and mammalian risk issues, and the Environmental Fate Effects Division, which focuses on environmental risk issues. The statutory standard that directs EPA's decisions under FIFRA, one standard is no unreasonable adverse effects on the environment. That's defined to include no unreasonable risk to man or the environment, taking into account economic, social, and environmental costs and benefits of use of any of these pesticides. As Lynn said earlier, these statutes are risk-benefit statutes, so I just mentioned that because we also have the Biological and Economic Analysis Division included in this group, which engages in a lot of that cost-benefit, risk-benefit analysis. I also want to mention the Pesticide Review Evaluation Division. We talked about some of the registration divisions that focus on the new or amended products. Pesticides are also subject to periodic reevaluation to confirm that they continue to meet our ongoing science and policy safety standards. And so PRD is in charge of that analysis and engages in that analysis currently on a 15-year cycle. So all active ingredients and the pesticides that they are formulated into are reviewed now on a 15-year cycle. As noted, as Lynn said earlier, as noted on the slides, in addition to being registered at the federal level, each state has its own pesticide regulatory program. In some cases that is primarily administrative, dare I say, fee raising or fundraising exercise, but there are states that have very mature pesticide programs and review the products and the underlying data and draw their own conclusions. That include the three that are listed up here: California, New York, and Florida. Additionally, the states which I think are nearly all, with federally approved pesticide programs, they're the primary enforcement authority and work with EPA regional offices as well. So what is a pesticide? As defined here, it's any substance or mixture of substances intended for preventing, destroying, repelling, or mitigating any pests. Each of those words, as you can imagine, is defined. When we say substances, we usually think of chemical substances, but under FIFRA, it's anything that would serve these functions. So, for example, there are microbes, bacteria and fungus, which are registered as active ingredients. They can be incorporated and used to serve a pesticidal function. Similarly, there are plant-incorporated protectants, which are pesticide substances that are intended to be produced and used in the living plant, typically through genetic modification. So all of these are regulated as pesticides under this program. FIFRA is an intent-focused statute. It's a substance is considered to be intended for a pesticidal purpose, requiring registration if the person who distributes or sells the substance claims, states, or implies that the substance can or should be used as a pesticide. So a lot of focus is given on what statements are made for the product and what the claims are. Additionally, though, it's objective standard. A product that contains an active ingredient and that has no other pesticidal purpose or no other purpose in the product other than functioning as a pesticide will be regarded by EPA as a pesticide. And similarly, if a person who sells a pesticide has knowledge that it can or will be used in that fashion, sort of the wink, wink, nudge, nudge test, EPA will regard that as a pesticide as well. There we go. The core statutory authority for pesticide regulation is in FIFRA, which can be found at the U.S. Code site provided. There's also authority under in the Federal Food, Drug, and Cosmetic Act. In addition to regulating pesticides and pesticide products, an important part of the regulatory paradigm is setting maximum levels, maximum pesticide residue levels, in food or animal feedstuffs. These are referred to in the United States as tolerances. EPA sets the tolerances for these maximum residue levels in foodstuffs, or determines whether or not a maximum residue level is required, or if a substance can be exempt from the requirement of tolerance. And then the Food and Drug Administration investigates and implements and enforces those requirements or those limits. Under FIFRA, EPA's jurisdiction over a wide range of different types of products. We have our active ingredients, which really are the chemical entities that impart the pesticidal effect. They're the ingredients that prevent, destroy, repel, or mitigate pests. Also included in the definition of pesticide are other products such as plant regulators, which are chemicals that affect the plant physiology. So a plant regulator might induce more blooms, so you end up with more fruit, or it might affect the plant so that the harvest, the fruit all ripens together, which facilitates harvest. Defoliants, desiccants, nitrogen stabilizers which act on soil bacteria are also regulated as pesticides. Again, the key part, or the conceptual link here, is that they're acting through soil bacteria. Those affect the rate at which fertilizer is converted to plant-available nitrogen, and ideally makes fertilizer more efficient. You end up with less runoff of nitrogen to surface waters and so forth. But again, because it's function and to have an impact on the soil bacteria that are part of that nitrogen cycle, for 30 botanists in the room, they are regulated by EPA as pesticides. EPA not only regulates the active ingredients, but it regulates and requires registration of the entire formulated product as it's sold, distributed, and used. And included in those formulated products are the other ingredients, the things that are not the pesticidal active ingredients, or what we refer to as the inert ingredients. Those can include things like solvents and surfactants and fragrances, or stickers, and the other things that would typically go into a formulated product along with the active ingredient to allow it to be distributed and actually function. Pesticides can be classified in a variety of ways. We have, again, the conventional pesticides, as we were talking about earlier, which is pretty much everything other than those things that fit into the biopesticide or antimicrobial buckets. There are a category of minimum risk pesticides under FIFRA Section 25B. EPA is authorized to exempt from regulation those pesticides that are of a character, according to the statute, that per EPA's determination, that don't require regulation. Typically these are, or not typically, they are pesticides that are formulated from a very discrete list of active ingredients and a very discrete list of inert ingredients. They have certain requirements attached, and this is a self-implementing exemption, but they can't make any public health claims. They have to disclose all of their ingredients on the label. And generally considered, as you would imagine, to be a relatively benign set of products, which is why EPA has exempted them from regulation, which is all well and good. I think a lot of state regulators and a lot of the states often will register these products, will tell you and the state enforcement people that there are a lot of so-called minimum risk pesticides on the market that perhaps are not compliant with all of those requirements. So that's a bone of contention, and it's a focus. EPA has actually recently, I think it was December, proposed an amendment to its current rule regarding minimum risk pesticides to at least clarify the components that are in them. Part of the way they're doing that is they're listing pass numbers now with these lists of the active ingredients and the inert ingredients, so everyone can be really clear about what's in and what's out, what's eligible and what's not. And that very well may be just the first of amendments in this area. Another kind of bone of contention is minimum risk for mosquito repellents, for example, and where the claims stop and when do they become public health claims. So it's an area of scrutiny and an area of some change. Another pesticide type, product type, treated articles, products that contain pesticides in them to preserve the pesticides, so called material preservatives, technically are pesticides, but If they don't make claims, or if the claims for those products are only to protect the product themselves and they are exempt from regulation under FIFRA. Classic example is paint. Paint without a material preservative can get pretty funky, and no one wants to pop open the lid and find all sort of little microbes crawling around inside. So paint is often treated, or a wide variety of products have material preservatives in them. Again, they are not subject to registration requirements, for example, under FIFRA, as long as the claims that are made for them do not extend past the protection of the article. Where you start to come to a line on these are products which incorporate a pesticide and then want to make, particularly for hard surface materials, want to make claims that microbes will be killed and therefore you won't catch something from using the article. And in those cases, those claims can be made, but then that article itself has to be separately registered as a pesticide with EPA because they want scrutiny on those claims, as you can imagine. EPA engages in the following activities as part of its core programs, just to kind of give an overview. First, as discussed, there's a registration program, first and foremost. And it registers new active ingredients, new uses of existing active ingredients, new products that maybe have a new formulation, or even, same old, somebody just wants to enter the market and compete with the other folks who are already out there, presumably on a less, cheaper, lower price point. These products are dynamic licenses, or these approvals are dynamic licenses, so they are constantly subject to review. Any changes that are made either to the formulation or to the claims or really any aspect of the product has to be subject to pre-market approval by EPA, review by EPA. So there's a regular set of submissions to EPA, to these registration divisions, of amendments and requests for changes to the products. So it's not only just new products. Additionally, as mentioned, EPA establishes residue limits or tolerances for food and animal feed. Pretty much making sure that anything that's going to enter into the food supply chain with these residues is safe for consumption. As also briefly mentioned, another area implemented by OPP is re-registration, or now referred to as registration review, the periodic 15-year cycle review of existing chemicals to make sure that they meet current standards. EPA, OPP also implements other permit and exemption programs. As examples, their new use experimental use permits. If a company, as we said, these applications and EPA's risk assessments are all data intensive, data rich. Those data need to be generated. A lot of that can be done in the laboratory, but there are a variety of data that are required in order to complete a registration for a product that require in-field or actual use. And so in order to do that, companies file with EPA for experimental use permits to be able to determine efficacy or confirm efficacy, to be able to figure out what the appropriate use rates are, to determine what the residues are when the product is used as intended. So those are all subject to EPA's EUP or experimental use permit program. There's Section 18 permitting and approvals. State governments apply for these to EPA if there is a emerging pathogen that's going to threaten a crop that comes out and there's not adequate product out in the marketplace to address that emerging pathogen. The state can approve, can appeal to EPA, typically with support of registrants, to, on an extremely expedited basis, approve the use of a product that maybe is not approved for that use, for that pest, but is desperately needed. And so EPA has an expedited way of a process for reviewing such requests to address such situations. Under its worker protection standards, EPA requires certain workplace practices designed to reduce or eliminate exposure to pesticides and establishes procedures for responding to exposure-related emergencies. Employers are required to ensure that workers follow these requirements, many of which are included on the label, as we'll talk about shortly. Handlers, for example, are required to use the protective clothing and equipment specified on the product labeling. Additionally, another core program within EPA relates to consultation on endangered species issues. In reaching pesticide approval review decisions, EPA consults with U.S. Department of Agriculture, with the U.S. Fish and Wildlife Service, and with the National Marine Fisheries Services regarding the potential effects of these products on endangered species, and taking whatever mitigation requirements or steps are necessary to ensure that endangered species are not affected. Basic concepts of the FIFRA's regulatory framework include, as I stated, pre-market approval. Cannot introduce a product to the market until it's been subject of an application and review with EPA, which includes everything from the formulation and the claims to every aspect of the labeling. This is a risk-based safety standard. EPA is to conclude that the product poses no unreasonable risk for non-food uses and reasonable certainty of no harm for food uses. At the most basic level, risk is a function of hazard, with kind of the intrinsic toxicity posed by the molecules, and exposure, which is of course related to its use, how it will be used, and what residues result, and what exposures that can be both to occupational users and end users, or anyone in the chain that might be used or be exposed to the product or its residues. And it's the burden on the registrant to meet the safety standard through typically the initial submission as part of the registration application, as well as the registrant's ongoing responsibilities to meet any additional data requirements that EPA may place on the product. To demonstrate that a product meets the applicable safety standards, the registrant must submit a significant amount of supporting data. The data requirements are included in 40 CFR for 158. They've all been for conventionals, for antimicrobials, most recently for antimicrobials and pesticides, updated in fairly recent years, going back to 2008, I guess, for conventionals and microbials, and just this year for antimicrobials. There are a battery of testing requirements that are all laid out in the regs, and they deal with all the different science disciplines that you would imagine would have to be addressed in order to conduct a risk assessment. So that includes everything from product chemistry, defining what the product is, what the active ingredient is, what all the inert ingredients are, how it's made, whether there are any impurities in the processes. It also includes mammalian and environmental toxicology, environmental fate of the molecule reacts and breaks down in the environment, residue chemistry, as discussed, how it what remains in the plant and how that breaks down and how it's metabolized. Exposure information, what exposures are on to the chemical and if it's used as intended. So all of this data must be developed as part of the application process, and as noted, it can cost, especially for a new active ingredient, millions and millions of dollars, and take a lot of years of planning and data development before the application even makes it to the EPA. And also, as noted, I guess I'll throw in, the regulatory program is pretty flexible. It's very case specific. Folks are coming out with emerging technologies to solve new problems all the time, and they raise new and interesting issues that can raise questions that perhaps the existing data set don't answer. So EPA has the authority to require additional data, usually identified and discussed on an iterative basis with EPA. OPP strongly encourages companies, registrants, to come in and talk to them if they're going to do anything new, different, novel, outside the box, to make sure that, the kind of the worst case scenario is if you go out and you develop and spend a lot of money and time to develop all these data, and then you go to EPA and they say, yeah, that's nice, but we really wish you had done it this way. Trust me, you wish that you had done it that way too, because it's back to the drawing board. Similarly, there are plenty of occasions when, one size fits all basically means one size fits none really well. So there are occasions where a data requirement just doesn't make sense. There are dermal toxicity data requirements, for example. If your product is fairly corrosive and will really irritate skin or destroy the skin such that you can't get appropriate dosing, you're never going to have an exposure that way. People are either going to have incredible incentive to wear personal protective equipment or otherwise we won't have exposure in that route. So, query why stress out and kill a bunch of animals unnecessarily when you're not going to get any meaningful results out of those studies. Just one example, but EPA does have a discretion to waive these data requirements as well. As we discussed under FIFRA, certainly there are confidential business information concerns with regard to pesticides. After spending a lot of time and money and ingenuity in developing new technologies, companies want to get the return on their investment and protect their confidential business information to the best of the ability and under the full extent of the law. Active ingredient identity and concentrations must be disclosed. That's required to be on all product labels. However, inert ingredients, their identities and their concentrations and manufacturing processes for developing these products are certainly amongst those things that are protected under and expressly protected under Section 10 of the statute. One can make arguments to protect other information as well, and the EPA will consider that, but it need to be substantiated. Generally speaking, EPA, and this is a trend across certainly across EPA for narrowing interpretations and enhanced transparency, and there has been some discussion of potentially calling for disclosure of inert ingredients as well. So we'll see how that plays out. Under that heading, since 2009, for all new pesticide active ingredients, first food uses, first outdoor uses, first residential uses, sorry, I have to refer my notes for this, and other actions of significant interest, however that's defined, EPA will place its risk assessments and its proposed decisions on a public online docket and allow for public comment for a 30-day period. So that's one way that this trend towards transparency is manifested. Certainly, the internet, online dockets, the availability of all this information, the click of a button has supported that. Another way that one's investment, to go back, well, my dad was a bit gone, but is the concept of data ownership and compensation for third-party use of proprietary data. The way that FIFRA is set up, a lot of data required. Companies that develop data for a new active ingredient are given a 10-year period of exclusive use. So they are the only ones that can use that data. Now that doesn't stop another company from going out and conducting the same testing, but clearly that's a big investment. After that 10-year period is over, other companies following registrants can come in and submit an application for registration and rely on those data. Though for data, either for new or for existing chemistries, if the data are less than 15 years old, the company that's relying on those data have to make an offer to pay data compensation to the data owner. And there's a process for setting that up. The data owners are published, and when a follow-on registrant submits an application to the EPA, it has to certify under the penalty of perjury that it in fact has made those offers to pay. At that point, EPA gets out of the dialogue. It doesn't want to have anything to do with it, and that's sort of an efficiency built into the law. What's required is that the data owners are giving notice that someone else is relying on their data, in which case they have every incentive to pursue that and to come back and say, okay, this is what you owe me. EPA stays out of it, but if the companies cannot come to a negotiated agreement on sharing the cost for the development of those data, binding arbitration is prescribed by the statute. So that's how that works out, and it works out fairly well. I mean, in this way you have protection for and incentives to develop data and to develop new technologies, but you also have this process so that you don't have wasted resources on duplicate testing, wasted resources on EPA having to review the same test twice. reduced animal testing being unnecessary. And it promotes competition. As soon as someone gets the opportunity to enter and develop the marketplace, but then they're not going to have a monopoly. Other companies can come in and produce competing products. If FIFRA were reduced to a single maxim, it would be the label is the law. All of the data and risk analysis that EPA goes through all gets boiled down to the product label. This is an incredibly scrutinized document. Every corner of it is prescribed by EPA. EPA basically implements all of its pesticide regulatory decisions through the product labeling, which describes, it lists the approved uses, the use directions, the approved crops and use sites, all the required engineering controls and personal protective equipment, whether there are restricted entry intervals after a pesticide has been applied, and pretty much every requirement or limitation applicable to the product's use. Not only do the topics have to be addressed, but the specific language typically is directed by EPA, and any changes to this language has to go into EPA for review and approval as part of the amendment process. Labeling and these requirements cover all written materials that are distributed with a product, so product specifications and so forth, in addition to the label that's adhered to the package. If the label or labeling refers to the company's website, that also is subject to EPA's review and must be consistent with the claims that EPA has reviewed and approved. As a result, what you often get is companies submitting for EPA's review and approval everything their marketing department might dream up, they might possibly say about that product, just to be clear that this is consistent with what EPA has approved. FIFRA has been revised several times. Most recently, in recent years, starting in 2004, there was the Pesticide Registration Improvement Act, PREA, and it's been updated since with the Renewal Act and the Extension Act, so we're up to PREA 3. This established a fee for service kind of structure that brought in significantly higher set of revenues for EPA to engage in all of these reviews and to pay the scientists and to pay for the infrastructure that's really needed to manage the throughput that comes through between new applications and amendment applications. This was strongly supported by industry and by EPA and by a variety of non-governmental organizations. One of the benefits that industry got out of this was a certain level of certainty. It put time limits on various types of applications. Currently under PREA 3 we have 189 different categories of applications that can go into EPA that are subject to PFVs. And they are, generally speaking, subject to a range between 4 months to the 24-month review period by EPA. It can be longer, certainly, if issues come up, and typically, as under TSCA with the amendment review, companies want to allow those time extensions if they are needed. I mean, obviously, they would prefer that they weren't. But when the alternative is having your application rejected, you clearly want to play ball and try to address any issues that EPA has raised so that you can get your product approved. Again, this is just a reference to, with regard to existing products, the fact that under EPA's registration review process, a 15-year cycle, products are subject to review. Let me just jump ahead. One theme under FIFRA is to promote the development of safer or reduced risk pesticides. This is encouraged through a variety of incentives, which include reduced fees and expedited review periods. There are also dedicated resources that are set aside within EPA to support these reviews. As we've already discussed, there are minimum risk pesticides, which as a set, because of their relatively speaking benign, I mean, we never call anything safe benign, but when used as intended, are exempt from regulation. Additionally, under PREA, for example, for reduced risk conventional pesticides, as long as the product is demonstrated to meet the criteria that EPA has set up to show that the pesticide shows, a lower human health toxicity profile, lower human health risk profile or lower environmental risk profile than maybe competing products in the marketplace, it will give that application an expedited review period. Similarly, EPA broke out and has separately managed biopesticides, which include microbial pesticides as well as biochemicals. As a group, these are generally considered to have propose a lower risk profile, and therefore they, as a group, have a somewhat reduced set of data requirements, and they are also subject to substantially lower fees. So those are some of the various incentives that encourage the development of these products. FIFRA Section 12, to go to the question earlier about various incentives. FIFRA Section 12 lists acts prohibited under the statute, which include the sale or distribution of pesticides that are unregistered or that differ in composition from what EPA has approved, or that differ in the claims that EPA has approved. And EPA, as well as the states in enforcement, have a variety of remedies for addressing non-compliant products. EPA has the authority to issue a stop, sale, use, or removal order, also known as a SHURO, to prevent the sale, distribution, use, or require the removal of a pesticide that's in violation of FIFRA. EPA is authorized to assess civil penalties. Each offense can be subject to a civil penalty of up to $7,500 per offense, depending on the type of violation and the size of the business. As in assessing those penalties, EPA will consider whether or not there's an economic benefit that has been achieved through the non-compliance, but also look at factors such as a company's good faith efforts to mitigate the violation or to self-disclose when coming up with these penalties. But certainly, there are some headline enforcement actions in millions of dollars, which, in addition to the adverse effect on the company reputation, are all sorts of incentives for compliance. And additionally, EPA is also authorized to bring criminal charges for knowing violations of FIFRA, which include monetary penalties and up to 1 year in jail. Let me briefly go through some more recent developments in recent years that are of some interest. We've talked about under TSCA nanotechnology. Certainly nanotechnology is relevant in FIFRA as well. A lot of technological evolution to come up with better products. For those nobody who raised their hands with regard to their chemistry backgrounds, a nanometer is 1/1000th of a meter, also sometimes 10 to the -9 in size. Nanoscale materials, generally speaking, we've gravitated towards a definition which defines them as anything that is less than 100 nanometers in any one dimension. And the reason this is important is that chemical substances generally tend to agglomerate into larger particles, and that's what's tested, and that's what has known properties, both physical and chemical properties, as well as toxicological properties. When you break that down into smaller particles, really things of this scale, frequently the properties change, and that's why everyone's interested in it. You're getting, same, chemistries that we're familiar with, but all of a sudden they can do new things, and that's great. They can do new things to solve problems in new ways, but the question then becomes, well, gee, we based our risk assessment on these chemicals based on these properties and this understanding of them, and now if they're going to have different properties, what does that do to our risk assessment? When is something that is the same really the same for regulatory purposes? When do we have to regulate it differently? In the June 17, 2000 register, EPA proposed to classify any nanoscale active or inert ingredient as new. This is not necessarily the approach that all of the EPA offices are taking, but it's the one that the OPP is taking. EPA also proposed for comment obtaining information in different ways about pesticides, existing pesticides, including whether it should be subject to 6A2, which we haven't talked about, but is comparable to TSCA 8E, which a registrant must submit under 6A2 any additional information it learns about its product regarding unreasonable adverse effects. As you can imagine, industry wasn't too key or receptive to the concept of having the fact that its product, which may or may not contain a nanoscale material, subject to 6A2 because that could have puts a really negative spin on that information. Another alternative that EPA has proposed for kind of getting more information about this is through the DCI, or a data calling process. And EPA seems to be pursuing that. They issued a DCI in 2012 as part of the registration review process for silver. Silver is one of these molecules. As I get close, how dead are we at 2? Silver is one of these substances that has antimicrobial properties and seems to, is being looked at for whether or not its bulk scale properties differ from its nanoscale properties. In 2011, EPA announced the conditional registration of the first first proclaimed nanoscale product, an antimicrobial product by the company HiQ, which contains nanosilver for use in preserving textiles. NRDC filed a lawsuit challenging the registration because EPA allowed the registration, allowed the product to go to market with some of the data to follow. And NRDC said, you should have required them to turn in all that data before you approved the registration. EPA responded, that they had adequate information to meet the safety standard to determine that the product would not cause unreasonable adverse effects to consumers, and that's where that decision currently stands. Another area of some focus relates to human health testing. There was a rule in EPA's rule in 2006 which placed significant restrictions on the circumstances in which EPA would allow consideration of voluntary human testing to support a registration in a process for assessing whether in-house such testing should be conducted. Most of the data that we're talking about in the context of FIFRA is all based on animal data, which is then extrapolated to relevance to humans with various safety factors to address the intra-species as well as intra-species variations. In 2011, there was a proposal to amend that rule and to add additional controls and safeguards, and as noted, these are recent developments, but also evolving developments. OMB has stated it's completed its review, but we haven't seen any movement on that rule. There's additional amendments to this regulatory area. Very recently, this spring, the U.S. District Court in the Northern District of California dismissed the so-called NEGA, Environmental and Endangered Species Act suit. In that suit, the Center for Biological Diversity versus EPA, the plaintiffs asserted that EPA improperly failed to initiate or reinitiate consultation for 382 pesticides, hence the NEGA part of the nickname. In that case, plaintiffs did not identify any specific registration action by EPA concerning which there was a failure to consult. Instead, plaintiffs based their complaint on the theory that EPA retains discretionary control over the pesticides and as such. That control constitutes an ongoing administrative action, but the court rejected this concept and theory, holding that the plaintiffs must allege separate Endangered Species Act claims for each pesticide, and that corresponds with an affirmative EPA act. On a related note, a committee of the National Academy of Sciences released a report on May 1 that had a series of detailed recommendations for upgrading the consultation process between EPA and the services. This was actually invited by EPA and the services, so it's expected that to the extent plausible, the EPA will implement those, and the services will implement those recommendations to the degree possible. I'm going to skip over, much to my firm's dismay, because we were involved with the Kaiser decision, and just note because of it's been widely reported in the press, pollinator protection is another hot area that EPA is very focused on. There's been widely reported decline in honeydew health in recent years. The phenomenon has been given a lot of attention, and the current thinking, at least in the United States, is that it's due to several stressors, including parasites and disease and nutritional deficiency, weather, genetic diversity, but also pesticides. Some jurisdictions have really focused on the pesticide element and have sought to limit or ban, as it says there, one solution, really the solution. Here, I think we have stakeholders are engaged in looking at the potential plurality of causes and trying to come up with a variety of solutions, which include additional management techniques for certain pesticides, as well as revising inventory labeling, but also more product testing and more investigation to sort of a plurality of an approach to solving the problem. So I think that is all I have, given that I'm 4 minutes over. But questions?